subscribe, please click the like button, share and subscribe. It's free.
The application has been withdrawn against the 7th respondent, the Minister of Justice and Constitutional Development, and the 8th respondent, the Judicial Inspectorate for Correctional Services, advised the decision. I will refer to the remaining respondents collectively as the respondents. As a preliminary matter, I wish to deal with the parties' attempts to introduce new evidence at the last minute. When the matter came before me on Wednesday, 6 November, the Respondents' Counsel, Mr. Madiba, complained that the applicants had attempted to introduce new affidavits shortly before the matter was called. I pointed out that there was no application before me explaining why it was necessary to introduce new evidence at such a late stage, and that I would consequently not take heed of the applicant's proposed supplementary affidavit. The matter then stood down until Friday, 8 November for argument. On Friday morning, the respondents suddenly wanted to introduce further affidavits. As with the applicant, there was no substantive application to supplement the respondent. The respondent could provide no explanation why the information in the proposed affidavit, some of which was already known to the respondents a year ago, had not been included in the answering affidavit. I took the view that what was good for the goose was good for the gander, and I declined to admit any further affidavits from the respondents. The applicants are awaiting trial for the murder of the well-known soccer player Mr. Senzo Mayiwa, and as I've said, they are currently incarcerated at the C-Max maximum security facility of the Khosi Mampuru 2 management area. C-Max comprises of 284 cells that measure approximately 2 by 2 in size. Prisoners are housed in these cells individually, and on the applicant's version, they are detained in their cells for more than 22 hours per day. The first applicant was transferred from Johannesburg Medium B to C-Max on 4 December 2020. He has therefore spent almost 4 years in C-Max. In contrast, the second applicant has been in C-Max for a little over a year. The first applicant is apparently incarcerated at C-Max due to his high risk profile. On the papers before me, there is no evidence that justifies classification. The first applicant says that he has effectively been held in solitary confinement for 4 years. He says that he suffered a mental breakdown on 7 October 2024 and that the strain of solitary confinement for such a prolonged period has left him unable to concentrate, severely stressed, with feelings of fear and hopelessness and suffering from insomnia. Due to his mental health issues, he has apparently been unable to provide his counsel in the criminal trial with instructions in the matter. The result is that the criminal trial has been interrupted. The applicant paints a dire picture of his confinement at C-Max. He says that for 22 hours per day he has no contact with other persons. He says that he has access to reading material, radio or television. On occasion he is allowed 1 hour exercise in a cage. He is allowed a cold water shower in a cage for 2 minutes per day. His telephonic contact with family members is limited to 10 minutes, twice per month, and 2 in-person visits of 30 minutes each per month. He is only allowed to consult with his legal team for an hour, twice per month. The respondents deny the first applicant's allegations. Specifically, the respondents say that the applicants are not in solitary confinement or in segregation. This is antics. If the circumstances amount to solitary confinement or segregation, call it what you will, remains solitary confinement or segregation. As far as the first applicant's mental health challenges are concerned, the respondents take a rather supine attitude. They say that if he has such problems, which they deny, he could have approached all manner of specialists. Considering that the Act places an obligation upon correctional services to see to a prisoner's well-being, the rather no-care attitude of the respondents is alarming. However, as I have said, I do not intend to make regarding the circumstances in C-Max. That is for the reviewing court to consider, and I will not tread outside the ambit of this application for interim relief. Suffice it to say that there is no dispute that a prisoner who is incarcerated in C-Max enjoys far less privileges and is subject to circumstances than prisoners in normal maximum security centres. Urgency. The respondents have argued that the matter is not urgent. They say so on 2 grounds. Firstly, the applicants have been imprisoned in these same circumstances for a long time, in the case of the first applicant for years, and any urgency, the respondents say, is self-created. Secondly, argue that it would make no difference to the applicants if they were detained at CMAX until the review application in Part B is heard. I have been referred to the judgment in Simon versus National Commissioner, in which the applicant applied to be transferred that his continued incarceration there amounted to torture. The court held that the urgency was self-created, in that it had apparently taken the applicant months that he was being tortured. The applicant's delay in bringing the application timeously was therefore fatal to the matter, and the application was struck from the roll. As will be seen below, this matter is distinguishable on the facts from Simon. Although the first applicant says that his incarceration amounts to torture in terms of Rule 43 of the United Nations Standard Minimum Rules for the Treatment of Prisoners, the so-called Nelson Mandela Rules, his case really hinges on the allegation that his further incarceration at CMAX is in conflict with the respondent's own standard operating procedures that only allow for the incarceration of a prisoner in CMAX for 18 months, save in certain exceptional circumstances. The first applicant has years. In my view, if a prisoner is incarcerated unlawfully, an application to rectify the position is inherently urgent. I will deal hereunder with the averment that the first applicant is unlawfully incarcerated. The first applicant has also alleged that the conditions under which he is incarcerated have caused him to suffer a mental breakdown. The allegation is denied by the respondents in a perfunctory manner, but they have made no effort to investigate the first applicant's complaints. They do not believe that the first applicant's averment should be rejected out of hand. I find that, as far as the first applicant is concerned, the matter is urgent. The same cannot be said for the second applicant. Although he says that he is also the victim of the same allegedly inhumane circumstances in CMAX, his continued incarceration falls within the four walls of the Correctional Services Act of 1998.
Family, today let's talk about the breaking news. Breaking news of accused number 3. What has happened in court about his case on being kept in a solitary confinement for no reason. So now the judgment is out and he has won the case. So what does it mean to the whole case? Because now we understand that it has affected his brains, which is mental state. So when we look at that, does it jeopardize the case? Will the case still go on? We will hear tomorrow. Because that judgment has to come to court and Judge Rata has to know about it. Because how can you proceed with such a case when somebody has been put in solitary confinement whereby they have damaged his brain? His mental state is no more good for the case. And another thing with his mental state, because he has developed an insomnia, which affects the brain, sleepless nights, and the memory. So how is he going to memorize everything now in court? Because all these kind of things were done by CMAX. They kept him in solitary confinement against his will. So I don't know, family, what do you think about this? This is a big win from Nube, accused number 3. Though I think accused number 5 will still appeal because he's been in the solitary confinement for less time than accused number 3. Because accused number 3 has been there close to 4 years. But for accused number 5, it's been almost a year, if not more. So another thing that I've listened to in this judgment is the CMAX vehemently denying that they are keeping these guys in solitary confinement. And they're heartless. This is being heartless. Those people need training before they get it. They must understand the constitution of the country and what damage does solitary confinement does to a human being. Those are kind of things that they have to know before they drop anybody, and they have to know when to put somebody in solitary confinement and when to take that person out of solitary confinement, because it's a way of disciplining any prisoner who has done something wrong in prison. So for him to correct him, they always put them in solitary confinement. But for these guys, there's no reason that they have stated in that court that shows that why these guys are kept in solitary confinement. Though number 5 did not win the case, but I think he will. He will appeal this case and he will win it at the end of the day. But my concern is number 3. His state of mind is compromised now, but by what was done to him in solitary confinement. Can he still stand a trial that is going to be fair to him and fair to the Constitution of South Africa? Does this jeopardize the whole case, this judgment? Let's wait and see what Judge Rata will do tomorrow when you hear this kind of news, because now it's evident that this guy has got mental issues. And I still wonder how he's going to stand this case. If Rata will be fair, he should throw this case out because of what has been done to this guy. So how is he going to remember things? Things that he's going to say in court. And when he is cross-examined, when he says he doesn't remember things, is anybody who's going to blame him for that? Because that was done by CIMEX, keeping him in solitary confinement. His state of mind is not proper by now, as we talk. Family, what do you think about this? Sometimes we have, because I think people, they don't understand why people are taken to prison. It's a correctional service. It's not a place whereby you have to go and damage somebody's mind. You correct the mistakes that they have done in the society so that they can be remembered back to the society. That's the way of correcting people, because you don't go there and stay forever. It's a matter of correcting you so you can see your mistakes and learn more things that you can learn from prison and come and display them out there. That some can be useful for individual, some they cannot be useful, because there are some people who just want to be in and out of prison. Family, what do you think about this? I think Mnisi, wherever he is, he's preparing himself for tomorrow, because this is his case. Because if his client has got a problem of memory, then it is going to be a big problem in this case. Is the judge going to throw out this case? Let's wait and see until tomorrow what really happens. Because Mnisi, I don't think he will let this one slip over. He will take the advantage on behalf of his client. Family, what do you think about this? The judgment is out. Accused number 3 won the case so that they can remove him from solitary confinement. So drop your comment respectfully and don't forget to like, share and subscribe. Noma izindlu zodala. Kusekhaya la. We are fixing our justice system as we are in social media, because there is no way they will hear us. I will know that they are watching each and everything that we are doing on social media, and that was confirmed by the judge who tried to say something about social media. Let's keep going, family. Bravo, bravo, bravo.